Great, thank you, and good afternoon, everyone. My name's Huw Ponting. I'm a partner and head of the personal injury team at Enable Law. This afternoon, we're going to have an exploration of functional neurological disorder, but very much from the perspective of a case that I had recently that has settled. So, what are we going to try and cover off today? First of all, I think it would help to put things in context if we looked at what FND is and also what it isn't. Often there can be some diagnostic challenges around FND. It presents, in my experience, sometimes again in quite a challenging way that we should all be aware of. We'll have a look at the role of experts, some of the challenges from a litigation perspective, and as I say, this is all based on a recently settled case. Although I'm conscious that both in litigation and in medicine, FND is quite an evolving matter. As has been said, we'll have time for questions at the end. So please do pop those in the Q&A. You can do so anonymously if you would prefer. So I think let's start perhaps by giving you some background as to this case on which this webinar today is based. So this involved a road traffic collision which took place in 2019, a two-vehicle accident, relatively modest in terms of the damage involved. Liability was admitted early on. This is a case that came to me actually in lockdown when the client changed solicitors, but liability had already been conceded. From the scene, the claimant had been taken to his local hospital. He had some relatively modest orthopedic injuries. There was a loss of consciousness recorded at the scene, but when investigated at the hospital, the conclusion was that there'd been either no or just a very minor head injury. So what happened from there? The client returned to work, but several weeks after the accident, he started to experience some involuntary movements in his hands, occurring first of all when he got up one night and couldn't manipulate the latch on a bathroom door. That progressed to the point where within a matter of months, he was suffering anything up to 20 to 30 seizures in inverted commas, and I use the inverted commas very much intentionally, but they really were quite debilitating. He had to give up work. It was having a significant impact on his and his family life. Because of the deterioration in symptoms, there was an INA commissioned through a case manager and an MDT put in place for this client. He had support workers. He couldn't drive, obviously, because of the condition. He had an OT and a psychologist. Initially, there was some diagnostic uncertainty for him as well as to whether or not he had FND or whether perhaps it was frontal lobe epilepsy, and that went on for some time, which certainly perhaps didn't help his situation. One of the things that the claimant had done prior to the accident was climb professionally in his job, not as a climber, but his job required him to climb and use a lot of the climbing safety equipment. And the OT decided it would be a good idea, because there were lots of other activities that he couldn't do, if perhaps he should try that. And he did so very successfully, to the point where he was even being considered for the British Paralympic team. The case progressed. There was an offer on the table, of several £100,000, quite significant. Um, the MDT continued, and then in 2023, the summer of, the funding stopped, from the defendant, and they wouldn't really say why, but we suspected that they had some evidence which they thought was obviously pretty damning. Um, Following on from that, shortly after, we received quite a detailed Part 18 request, so questions, formal questions put by the defendant to the claimant, which we took a long time dealing with counsel, and we were glad that we did ultimately. And it was not long after that then, that the surveillance footage that we thought perhaps the defendants had, was served, a lot of it focusing on his use of a couple of climbing walls locally. And the defendant experts very much straight away focusing on what looked to be a very able person in the surveillance, but who otherwise, in terms of his presentation to them, and also referenced in witness statements, appeared to be quite disabled. On top of that, then they raised fundamental dishonesty. That was then subsequently pleaded. And we mustn't forget, and I know we're not all lawyers on this webinar, but the potential ramifications of the defendants being successful with allegations of fundamental dishonesty, which effectively can mean that the claimant receives nothing by way of damages, not even those parts of his claim which ultimately a court might think aren't touched necessarily by the dishonesty. A significant cost penalty, not covering your own costs, being responsible for the defendant's costs, and also a potential custodial sentence for contempt of court, in the sense that the case that's been advanced with statements of truths to append to documents, effectively then being different to that which the court found was perhaps the reality for that individual. So quite significant. The experts struggled with the case on both sides, and then in joint statements we had a failed joint settlement meeting. Ultimately, the case settled for 1.5 million, which was a lot less than had initially been thought the claim was worth, but equally a lot more than nothing if the defendants had been successful with their fundamental dishonesty. And so really quite a challenge. So I think to further set the scene, whilst many personal injury claims, of course, can be very difficult and complex because of the medical science involved. What I would say is that I think FND poses particular challenges to the claimant in terms of proving its legitimacy, not least in our adversarial legal system. It is a relatively new feature in personal injury litigation, but one that's becoming increasingly common. And we'll talk a little bit about diagnosis or condition, as we lawyers will often refer to it, causation and prognosis, and in addition to that, treatment as well. The challenges around how the claim is put, how it's pleaded, and then the allegations that can follow in terms of exaggeration or fundamental dishonesty. So thinking about functional neurological disorder, there's quite a history to the condition in terms of how it's been regarded and defined by the medical profession. Going back to its early days, being considered hysteria or then a conversion disorder with effectively psychological symptoms converted into sort of physical symptoms or manifestation. Somatoform disorders, non-organic illness. So there's been quite an evolution over time. But I think, and probably quite sensible, there's been a move away from the condition being regarded very much as a psychological condition to much more of a focus on the neurology of the diagnosis, to the extent that whereas perhaps once it was more fashionable to get to a diagnosis after excluding other causes, now we're encouraged to think more about a positive diagnosis. So those diagnostic signs being perhaps involuntary movements or sort of seizures, variable or inconsistent sensory loss, incongruent weakness. Weakness that perhaps might be present during voluntary affect, but not present during involuntary movement. What does that mean? I've got a colleague whose wife is a physiotherapist. She has a patient with the condition who, when they walk, they drag their one foot. And yet, if they're given a plate with some plastic balls on it and asked to walk across a room, the act of concentrating on the balls on the plate means that then that person no longer drags their foot. So we think of it more as a change to the way that the brain works rather than damage to the brain itself. That there are genuine physical symptoms, albeit not necessarily explained by changes to the brain structure. And I know that many of those participating this afternoon, listening from the medical profession, will be aware of some of the advances in functional neuroradiology, which perhaps might help further in terms of diagnosis going forward. Typically symptoms can be any of, and some of these singularly or in combination, seizures, movement problems, dizziness, issues with speech, pain, fatigue, or issues with vision or hearing. So quite a broad range of symptoms, which is why there is often then that challenge in terms of diagnosis and treatment. There can be a period between the trigger event and onset. So for my particular client, that was weeks, but equally it can be longer than that. It can be triggered by physical trauma, as it was for my client, but equally psychological trauma. It can also be dormant in those with quite complex history of trauma, abuse, or stressful episodes in their life that occurred pre-accident or pre-index event. So again, quite complicated. And there's no necessary correlation between the development of the symptoms experienced and the severity of the initial event that they might be linked to. The accident that my client was involved in was, at the end of the day, relatively modest. But the progression of his symptoms from that initial sort of involuntary movement, loss of sensation in his fingers quickly developed to what appeared to be sort of full-blown seizures. But again, that can vary from client to client. We know that neuroimaging can often be normal. That again, there's no single or specific diagnostic test. and also no biomarkers or biological signs. There's no blood test for FND or DNA test. Um, and also, it's not uncommon for it perhaps first to be considered within the medico-legal system, in the sense that you've got your client, or as a defendant, you're faced with the claimant's claim, and there won't be necessarily a history in the notes resulting in a diagnosis of FND. It could well be one of the medico-legal experts that picks it up for the first time. And in fact, on the case that I dealt with, even one of the experts, an expert in FND, initially thought that actually the diagnosis was one of frontal lobe epilepsy that wouldn't then have been causally related to the accident. So we look for those positive diagnoses for clients. It's very important to consider that the history, the symptoms, as well as the physical examination. It can also coexist with other disorders. And as I've said, there are some investigations that you would do, but they would be more focused on trying to rule out other disorders. And if you've got a claimant who has in their medical history references to abuse, significant psychological trauma, etc., then it's quite important to consider those with the experts. So when it comes to experts, again, it's an interesting diagnosis in that it sits within the sort of the sphere that you'll see, although neurologists will obviously usually take the lead. You'll often get input as well from neuropsychiatrists and from psychologists, understanding as well that there can be that coexistence between FND and other neurological disorders, to include also depression or PTSD. So you're not going to often have just one expert that you will go to, but rather a team, and quite important then to be getting those experts together early on to discuss the diagnosis. It's trite, isn't it, to say that it's so important for experts to have a complete set of the medical records. But again, perhaps surprising sometimes when you talk anecdotally to professional colleagues where that hasn't been the case. Witness statements are, I think, one of the really important tools that we have to be able to assist within the litigation. Looking at family history, if there is a family history of other trauma, dealing with that, symptoms that existed at the time, the treatment, etc. And very, very important that we don't let the client exaggerate their symptoms in their witness statement. Just so important, or it will come back to bite. That we deal with things with a cool, level head. It was quite helpful in this particular case because the claimant's family had taken quite a library of video footage showing the progression of his symptoms, which was something that the experts found very, very helpful. Those had already been taken at the point where we took over conduct of the matter. But I think if you have got a patient with this diagnosis where there is that progression of symptoms, it could well be useful to ask, if they don't find it too intrusive, to start building that history of video footage. And as I've already said, very important to understand the broader family history, and that also function can vary very significantly with this condition. So, what are the challenges to litigation? And this is very much from the perspective of this particular case. Firstly, that of diagnosis. We've discussed that already. The possibility that there might be other psychiatric diagnoses present, or even personality disorders. Thinking very carefully about which experts we instruct, when, and which discipline you go with first. I think if you already have, or if the client already has a diagnosis of FND, then I would be looking at a neurologist, and a neurologist that has significant experience of dealing with FND, and then let the other disciplines then follow on from that. And important as well, always to consider additional experts. We did have a care expert in our case because of the amount of care that the client required. Initially provided by family, and then by his professional MDT, then back to family when the funding was exhausted, and then back post-settlement again to professionals. We did involve counsel quite early in this particular case. Once the expert reports started coming in, and again that proved very valuable in the long term. I can't really speak because I only do claimant work, but I think from the defendant perspective, obtaining copies of the medical records, requesting early disclosure of medical records would be very important. Looking to see if there is that diagnosis of FND, and perhaps yourselves then thinking about, is your strategy one of also commissioning evidence early from experts, or are you going to wait to see what the claimant discloses, and then think about how you respond to that? The statements, I think, are very important, and very important for the experts to have those before they report. But the importance also is of just taking a lot of care over the content in those. The last thing you want is to be taking good early statements which you will update in due course, but then an absolute disaster to the claimant if, as the case develops, there is an inconsistency between statements of case, the expert reports, and then perhaps any surveillance footage that the defendants might commission. And I've already spoken about other potential evidence that might be available that might be helpful. I think, and this is of course the case, isn't it, with all significant litigation. The litigation itself is often a stressor for the client. You're having to see a lot of medico-legal experts, and there's always that focus on the negative, what you can't do rather than what you can do. But where you have something like functional neurological disorder, it could be further complicated in that there is a responsible sort of body of medical opinion that would say that it's very difficult often to treat FND when the litigation is ongoing, because the the best way of getting maximum impact for the client from treatment is it's almost a single shot. And so better to wait until you've got the stress of the litigation out of the way, then have the treatment, so you give it its best chance of success. But of course, that then results in challenges around, well, what's that what's that treatment going to look like? How much is it going to cost? And ultimately, how successful will it be, leading on to what the prognosis might be for that individual. This particular client did have that professional team involved in the day-to-day sort of management of him and the condition as best they could, and that's very helpful. And again, one of the complications around FND is the fact that often the treatment will have to be multidisciplinary, looking at what physical therapies the client might best benefit from, occupational therapy, physical therapy, the involvement of a psychologist, possibly a psychiatrist, neuropsychiatrist, or somebody from neuro-rehabilitative medicine, plus then looking at any medication for secondary symptoms, anxiety, depression, and possibly pain. Inpatient treatment for the client might be what is indicated. There aren't a great number of places nationally that offer specialist inpatient treatment for FND, and it tends to be extraordinarily expensive, in the tens of thousands, and also, as I've said, prognosis can be variable, and how that then factors into your schedule of loss is something that you're going to need to think very carefully about, both as a claimant and as a defendant, as you respond to the claim. We looked at a number of possible outcomes on a sort of a percentage basis. So there was a certain percentage chance that with treatment the client would achieve a very positive outcome, a somewhat positive outcome, remain the same, possibly get a little worse, or even end up long term much worse off than he was. Quite difficult as well, obviously, to factor in contributory negligence if you're also thinking about very expensive treatment. If there is contributory negligence in the claim, is the client really going to want to spend 50, 60, 70,000 pounds on treatment if they've only recovered 50% or whatever the percentage amount is of that in their claim? We did have a very carefully crafted and very long Part 18 request from the defendants in this case, which we literally went through with a fine tooth comb, and thank goodness we did, because of what then followed in terms of the surveillance footage. As I say, I only do claimant work, but I think if I were a defendant and you're looking at a case like this, with such a challenging diagnosis, difficult issues around sort of presentation, etc., why wouldn't you spend a few £1,000s surveilling the claimant, because of the benefit that you might potentially get from that? And again, from the claimant perspective, that's why we need to take the utmost care with the way that we put the claim. Um, and not forgetting, fundamental dishonesty. I do, with my claimant hat on, have uh, a bit of a bugbear with fundamental dishonesty, in that it can have a very significant impact on a claimant, who then subsequently is shown not to be fundamentally dishonest. It's a bit of a sort of a hand grenade that can be thrown in a room by defendants, and have a significant impact. It can be something that's raised by defendants, maintained right the way through to trial, with all the additional sort of stress that brings for the claimant, only perhaps then to be abandoned at or shortly before trial, but with a degree of then impunity. So I think, I don't know, we might see perhaps the law evolve somewhat in terms of fundamental dishonesty, and not just the consequences for the claimant, but also for defendants as well. So, in conclusion, I think that the message is, just vital that we, as practitioners, whether as lawyers, on the claimant or defendant side, barristers, medics, that we really understand the condition, the diagnostic uncertainty, the issues around treatment, causation, prognosis. Vital from a claimant perspective that you really do know your client, that you think very carefully about how you start to collate your evidence and build the claim, certainly in terms of witness statements. To think about that early involvement of experts, but perhaps with specific instructions early on not to consider prognosis. Think also about counsel early on, and perhaps we've all got our bank of experts that we like and trust, and counsel as well. As soon as fundamental dishonesty starts to become a feature in a case, if it wasn't already from the outset, I would be on the phone to some of my experts, just getting a no obligation bit of feedback from them, as to what we perhaps might need to think about. I work on the basis that with these big cases that are pleaded in the many hundreds of thousands or millions, that we are going to get, well, if not get surveillance footage, that at least the client is going to be surveilled, because again, from the defendant's perspective, why wouldn't they do that? We'll need to think about treatment. Can that realistically be undertaken whilst the litigation is ongoing, or will that have to wait until the matter is settled? What does that mean then in terms of prognosis, and how we're going to then plead the future loss in the claim? And I think, just to finish, it is, yes, a complex condition. It's one that we didn't see a relatively short number of years ago, but it is becoming an increasing phenomenon and presence in litigation. It is becoming better understood, although I think we've still got some way to go. There are good experts out there who can assist, and I know from personal experience that includes those at NRC as well. So that's my sort of whistle stop tour, and just sharing some experience from my own practice. Very happy to take questions, or perhaps for people on the call to share their own experience.
Lovely. We've got some
Kate.
great questions, Hugh. Thank you so much. Really fascinating to have things applied to a real case. Can I just ask you to stop sharing and then we can go to the when we can see you when we're talking. So I'll come to the questions that were in the chat first. So um, how do you see the potential for using a single joint expert in FND cases as a way of reducing the stress on the client?
Yeah, that's a good question. Um, uh, it's an option, um, but typical lawyers answer. I think it's such a complex diagnosis that comes with so many different challenges that I think there could be quite a lot of pull, from either side of that expert. And I, I think that would make it quite a challenge to be looking at a joint expert, particularly if they were focusing on the diagnosis, the causation, treatment, and prognosis as your lead sort of expert. I think if you were looking at some of the other more perhaps, and I hope nobody takes any offense, but more peripheral experts, then I think perhaps there's a better case there to argue that you could consider joint instruction.
Thank you very much. We've had a question here. Whilst appreciating the need to get the full suite of evidence, how do you balance this with the knowledge that a patient is only likely to get better with treatment, and generally treatment is only going to be beneficial post-settlement? So the sooner you get
Mm.
the matter settled, the better.
Yeah, yeah, and that's the difficult balance with these cases. And our system doesn't perhaps necessarily help in the amount of time that it takes, particularly perhaps once you've issued court proceedings. But I think as soon as you're aware of that diagnosis of FND, um, and then an awareness that the treatment might have to wait until the conclusion of the litigation, I think that puts us under a duty, certainly on the claimant side, to get on with it, frankly, and to try and move things along as quickly as we reasonably can.
Lovely. I had a couple of questions from Claire, and she says, does the CSOL, so the claimant solicitor, let the client know they may or may not be under surveillance by the other side?
Again, a good question. Um, I mean, the surveillance that defendants undertake can be, multifactorial as well. So, I know that a lot of third-party insurers will, once a claim is notified to them, a more significant claim, do a trawl of the claimant's social media footprint.
Mhm.
Um, I will often mention that to claimants at the outset. Um, I do also mention the possibility of surveillance, but again, it has to be done in a very careful way that you're not further damaging the client. But I think looking at it the other way, if a client was surveilled or something was picked up in their social media, and they were to say after the event, well, why didn't you tell me that the defendants might be doing this? Then am I failing in my duty to the client?
Thank you. Yeah, it's tricky. I've had a couple of questions about if FND is considered a psychiatric illness or separate from psychiatry. And someone has asked, can the defence solicitor command that further rehab funds will not be given unless the client has a psychology or psychiatric assessment? As this case manager has had clients with conversion disorders and they always refuse psychological assessment.
Yeah, yeah. Again, that's a challenge, isn't it? That the defendant holds the purse strings, unless you've got the evidence and your post issue where you can, put an application before a judge for an interim payment if that's what's needed. But in terms of withholding funds until I mean it's tricky, isn't it? I mean I think it's I can understand sometimes why defendants might do it. At the end of the day, I mean, they might decide that they want a particular expert to report. Of course, they don't have to then disclose that report. I think a defendant obviously as well has to have reasonable opportunity to investigate a claim that is put to them.
Mhm.
So again, the circumstances of every case are going to be different, but there's always going to be a balance.
Absolutely. And we've had a defendant solicitor just wanted to explain that they don't routinely watch claimants. There has to be legitimate concerns that symptoms are being exaggerated. We're also aware of the fluctuating nature of FND symptoms and the adverse impact that surveillance might have on a genuine claimant. And I think
Mm.
that's really interesting because, yeah, it's clear there's so many nuances with FND cases.
That's right, and sometimes surveillance can be done in an extraordinary sort of clumsy way.
Hmm.
You can have circumstances where surveillance is disclosed, and the client will say, I had no idea. And sometimes I've had clients come to me and say, I don't know what's going on, but I've had a van parked outside the house for the last every other day for the last sort of 3 weeks. And I've started seeing the same people in places where I wouldn't expect necessarily. I live in a small village. I know everyone, and then all of a sudden I'm seeing the same person in the village shop every time that I go in. I had a case once where my client's father worked in quite a sensitive team, a counter-terrorism team within the Met. The client um, thought that he was being surveilled. He was definitely being surveilled, and we had to go to the defendants and say, "Look, you need to let us know whether you are or you're not." And of course, they wouldn't tell us. And quite unusually on that one, perhaps, but we went before a judge and said, "Look, our client's father has got a very sensitive role in the Met. We need or he needs to know whether or not the surveillance is related to the litigation or might possibly be more sinister in its origins. Never had that before, never had it since, but that was quite a challenge.
Yeah, absolutely. Um, Ashish McAdam, who's one of our experts, has asked, when describing the impact of a functional disability, is it acceptable to use evidence from similar non-functional disabilities given the lack of evidence in FND literature and research?
Sorry, just say the first part of that again.
So when describing the impact of a functional disability, can you
Hmm.
use evidence from similar non-functional disabilities? So when he's saying kind of cross symptoms, because there's another question as well about, what kind of evidence carries the most weight in these cases. So,
Hmm. Um, I mean, experts, whenever they report, I mean, they're reporting on the person that's in front of them, perhaps first and foremost. So, what one can see, and perhaps a physical examination is going to be very important. Um, and then obviously, accessing the notes and the other material that they've been provided with. And then, as we see in every report, experts will then, often refer to a body of literature which they have, had in mind when reaching their conclusion. So again, every case is going to be different. I mean, the one thing I sort of always countenance experts to be careful of is, you know, just be careful, perhaps, being seen to go out on a limb,
mhm, yeah.
no pun intended.
So we've had a question. Due to the clear difficulties in both claimant and defendant cases, would it not be a good idea to include education to assist with understanding during litigation of an FND case?
Yeah, and actually that's really really important. So one of the bits of feedback that we have really sort of early on with this, especially where there's perhaps a differential diagnosis, is that when eventually an FND diagnosis is settled on, it's very important that the client, as best he can, understands why that diagnosis has been reached. And that they accept it, because if they don't accept it, then that is going to make treatment very, very difficult, and the treatment will involve as part of the approach in probably most cases a degree of psychology or neuropsychology and neurorehabilitation.
Mm-hmm. That's interesting. Someone's asked quite a big question, and I will caveat with this is just in your opinion and your position. Why are we getting more of these cases?
Um, I think it's just that these cases would have been labelled as something else, or these diagnoses
Mhm.
would have been labelled as something else, even 5 years or so ago, some sort of somatoform disorder, or possibly that the claimant was exaggerating or manipulating their symptoms in some way, that they weren't genuine. So I think we've just got a greater understanding, and are getting ever more a greater understanding of FND from a medical perspective, and then that's sort of pulling through then into the sphere of litigation.
Oh, interesting. Someone has asked, do you know how your client is now functioning post-settlement? Have you had any updates from them?
Hmm. So he's due to undergo his inpatient treatment imminently. So we'll see. He did see some improvement initially post settlement. I mean the run up to settlement, particularly with the allegation of fundamental dishonesty, was a hugely stressful period for him, to the point where his seizures were going up in number to, and I say again sort of seizures, up to 70 a day,
Wow.
extremely
Mhm.
debilitating, including from a physical perspective. When your body goes into spasm in the way that his was, it was exhausting physically. So he has seen some reduction in the number of seizures that he has. He tells me that he generally feels calmer and a bit more relaxed, but he's still experiencing a lot of these episodes every day. And there is a
Thank you for that.
chance, as the experts highlighted, that um, post treatment, he could potentially, still end up or be worse than he is at the moment, or he could see, dramatic improvement. There's such a
Mm,
broad range of potential outcomes, and that's what makes it then so very difficult for the lawyers then to plead the claim financially.
absolutely. And we've had a question, and this is this person's experience. Why do you think clients seem so reluctant to spend their settlement funds on further rehabilitation of interventions? Have you ever experienced that?
Mm. Funnily enough, I was at an event last night where this came up, and we were sort of discussing the difference often between where defendants are funding something under the rehab code
Mhm.
versus offering an interim payment. And I think psychologically, a client sees funding under the rehab code, it's sort of out with the litigation. And they don't sort of see that as their money. Whereas when they get an interim payment and they have to fund something, and particularly if that intervention is quite costly, then it's well, I don't know I'm going to get it back. And of course, that's further then exacerbated if there's a likelihood that there might be, contributory negligence. Further, and again from a psychological perspective, if the claim has been pleaded at one figure, but then the claimant receives a figure which is significantly less, then they're thinking, well, I haven't recovered all of my losses, so I've got to cut my cloth in terms of what I spend the money on. I think what's interesting from this particular case, my client is, he is still going to spend the 50, 60, £1,000 on private inpatient treatment, because that's what he believes will give him potentially the best outcome.
Mm.
But I
And
accept
someone,
that not all clients have that mindset.
yes, and I guess it's just very individual, isn't it? Up to, how people react to a settlement. As someone has just mentioned, maybe payment should be linked to the purpose for, during litigation. So, with the interim payments. And then I've just had a question. I've had FND clients when after multiple testing from all medical faculties, they're told there's no disorder, then the client suddenly develops a new issue elsewhere in the body. I mean, how would you handle that legally?
Well, I mean, these cases have to be led by the expert evidence. So, and again, I think it's why it's so important to have, your experienced counsel involved relatively early on as well. It's tricky, isn't it? Because I think that the timing of instruction of experts is very important in all cases, but perhaps, especially so here. Who you go to, in what order, when, and to report on what, is, is just a balance that we need to get right. But FND, it's a tricky thing from the perspective of diagnosis, causation, treatment, and prognosis. That's what makes it such a challenge, both for the medical profession and for us as lawyers as well. But I'm afraid there's no easy answer.
Thank you, Huw. So that was the last of the questions from all of our attendees. So I just wondered, what's the one thing you hope that people will take away from today that you hope everyone will go away and know about FND going forward?
I think really, it's about an understanding of the condition. Do your reading around the subject. I think the more complex the potential injury and diagnosis, the more incumbent it is upon us as lawyers to to read those medical and scientific papers, and of course to keep in touch with and to network with your medico-legal colleagues, whether that's at conferences or otherwise. It's important that I think that with a diagnosis like this, that we evolve together as we understand more about FND.
Thank you so much. And obviously, this is the second webinar we've done on FND. There's a big appetite for it. So, we'd love to hear from people with other kind of angles or other kind of topics that they want some support with. But thank you so much for today, Huw. That was really interesting. And yes, we will send everybody a recording and the slides in the next couple of days. So thank you, Huw.
Thank you all. Bye-bye.